Right, please, your lordship.
Yes.
With the consent of the undersigned, I beg to mention item number 26, my lord. Mr. A.K. Maheswari has some personal difficulty today. Lordship, may kindly
Item
take-
number 26.
Yes, ma'am. Mr. A.K. Maheswari has some personal difficulty, my lord. It may taken after a week, my lord.
Okay. Mr.
Yes, Mr. On behalf of
R.S. Misro, learned counsel appearing on behalf of Mr. A.K. Maheswari, learned counsel for the petitioner. With consent from the other side, press for listing the matter after
a week, my lord.
a week.
My lord.
Fair lord. Yes.
On the ignition metal, they expect that. Okay, so this for
Senior court. Go to senior court.
I just for order stay retaining and order implementing of parties, item number 1 and 44.
Yes, you are for
Lord, I am for petitioner, my lord, of this,
petitioner.
my,
In WPC number 2803.
in WBC number, my lord, I am respondent.
In WPC, you are respondent.
Respondent number 7.
You filed the application, IA.
My lord.
IA number
IA number 2, my lord.
2803. 2803 is for vacation of the interim order.
Yes, my lord.
And IA number 3602 was filed by
Me, my lord, to implicate writ petitioner. Earlier that IA, I have not implicate the writ petitioner as a party respondent. By this application, I wanted to implicate the writ petitioner as a party respondent in the IA.
the writ petitioner is before this court today.
No, my lord. What happened, my lord? If lordship go through the page number, my lord, 52 of my IA 2586, it will come like, my lord. What happened that in,
IA number 50 or page number 56.
my lord,
Yes.
2586, main IA, my lord.
Hmm.
Yeah, in last part, 54, page 54. Writ petition was disposed with a direction to the writ petitioner to file an appropriate appeal before the commissioner within a 10 days, madam. And subsequently, by last line, the till the appeal is disposed of, the interim order so and so passed by this court shall continue.
Okay, the main writ petition has already been disposed of.
Disposed of.
Okay.
And in that dispose of writ petition, this interim order is continued. The writ petitioner till date did not file any appeal. So, my lord, more than 2 years I have not getting my salary. Though I have times and again approached before the, my lord, respondent authority.
Whether notice was issued in this matter,
No, my lord.
in this IA?
That in this petition, as I have not made party the writ petitioner, so notice was not issued. And that is why by last order, my lord,
So,
court ordered me to
by
implicate.
this IA, your IA number 3602, you are praying for impleading him
Writ petitioner.
as a party in this IA.
I am, my lord.
Okay. Okay. Heard, Mr.
M. Hossain.
M. Hussain, learned counsel for the petitioner, no, for the applicant. This interlocutory application is preferred. Mr. Khatuniar, you were for the respondent.
Yes.
Any objection?
No.
No objection. Mr. Khatuniar for the response, opposite party, respondent, opposite party. This application under order 1, rule 10 of the Code of Civil Procedure is preferred by the applicant for implement of the writ petitioner, namely Nilokanto Talukdar as respondent opposite party number 7 in IA civil number 2586 of 2025. The learned counsel for the applicant submits that the that Sri Nilokanto Talukdar, who is the petitioner in WPC number 2803 of 2021, is required to be implemented in the IA number 2803 stroke 2021 as respondent stroke opposite party, as said Nilokanto Talukdar has preferred one writ petition being WPC number 2803 of 2021. And the said writ petition was disposed of by order dated 17/2/2023 by directing the petitioner Nilokanto Talukdar to file one appeal before the Secretary to the Government of Assam School Education Department Elementary respondent number 1 within a period of 10 days from that day, and further it was directed that till disposal of the appeal, the interim order dated 12/7/2021 passed in the said writ petition shall continue. The learned counsel for the applicant submits that since passing of the order on 17/2/2023, more than 2 years elapsed, but the petitioner, but Sri Nilokanto Talukdar has not preferred any appeal before the respondent authority as directed by this court, and that the interim order dated 12/7/2021 passed in the aforementioned writ petition is still operating, for which the petitioner has been depriving of the applicant herein has been depriving of his salaries. And as such, to vacate the said interim order, the applicant has preferred one IA, being IA civil number 2586 of 2025, and the same is pending adjudication before this court. And inadvertently, the said writ petitioner of WPC number 2803 of 2021 has not been implemented as a respondent opposite party in the IA number 2803 of 2021, and on such count, the notice would not be issued to him, and therefore the present interlocutory application is filed to allow amendment of the aforementioned interlocutory application dated 2586 of 2025 and to implement said Nilokanto Talukdar as respondent opposite party number 7. Accordingly, now, having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the WPC number 2803 of 2021 and the order dated 17/2/2023, and also the interim order dated 12/7/2021. Taking note of the submission of learned counsel for both the parties, this court is inclined to allow this interlocutory application. Shri Nilokanto Talukdar, the writ petitioner in WPC number 2803 of 2021, be arrayed as respondent stroke opposite party number 7 in IA number 2586 of 2025. In terms of this IA stands to dispose of. And in view of the order passed in this IA, the learned counsel for the applicant in IA number 2586 of 2025 shall file amended cause title within a period of 1 week from today.
My lord, already I'm ready, my lord. By tomorrow, my lord, I will file and my case may be fixed another day. Already,
No, you first file the amended.
my lord,
Thereafter, the rest will list the matter before the court.
urgent, my lord.
On such amendment petition being filed, the rest shall list the matter before the court as soon as practicable.
Bless you.
Items for admission. Numbers 2 and 3, order made.
Okay, Mr. A. Phukat,
Hmm.
can he be taken after some time? He's not right now in the court. It's coming. After some
Okay, madam, you say this WPC, these two WPCs are pending since the year 2015 and 17. Ask Mr. Fukun to remain
My
present.
lord, may I kindly be taken at 2 p.m.
2 p.m. 2 p.m. it may be difficult. Before 2 p.m. we may finish our works. You try to make it convenient to remain present before that. Okay, okay.
Right.
Item number 4, order made.
May please your worship, my lord, I was supposed to file a reply, lordship, to the affidavit in opposition filed by the respondent number 6, lordship. Lordship, but what happened, lordship, the petitioner was due to his illness, lordship, he was admitted at Hyderabad one hospital, lordship, but recently he came back, lordship. So he requested me to take it after 2 weeks, lordship, so that he can come here and start the reply.
Okay. And it may be given. Update may be given in the month of June.
So that may be.
Heard Mr. N.S. Morhuya, learned counsel for the petitioner. Ms. Musahari for the respondent number 1, 2, and 3. And Mr. Purkaisto for respondent number 4. Yes. 4. Mr. Morhuya submits that the petitioner will file his reply to the affidavit in opposition filed by the respondent number 4. 4 or 1, 2, 3? 4. And as the petitioner was undergoing treatment in Hyderabad, he could not file the reply affidavit in time, and he pressed for listing the matter after 2 weeks. We are allowed, SSL list the matter on 4 weeks. 8th of December.
Item 5, order made.
Last occasion, lordship has asked from them whether that the compulsory retirement, the date of compulsory retirement should be the date of granting the pensionary benefit. That is simple. So 1/1/2011.
So that is your contention.
Yes, lordship.
Who is for the respondent?
On favor. Anand Dastan.
Pardon?
Anand Dastan.
Instruction is-
Instruction I see. Dates them. 1/1/2011.
RM Das. Is he present in the court? Huh?
Copy to there, okay? Copy to there.
Oh, yeah, instruction, receipt instruction.
Yes, have you sent the instruction? No. You furnish a copy to him right now? Mr. Purkesh, so better you do one thing, you go through these instructions. You, after some time, you appraise this court. If it is agreeable to you, we will close the petition. Copy.
Item number 6, pardon, madam.
Lordship, my lord, in this case, annexure 6/23. This was the order sanction, some outstanding not paid. So my prayer that I am continuing till today with the work. And it is also informed in version of the petitioner that some other area also sanctioned. This may verify and may be passed order for releasing the said money, my lord. Case 23, my lord, NSR 6, preliminary, 6 months only paid, remaining remuneration not paid, my lord. Till I am working, my lord. The annexure 8 also there, further pair for, because I am continuing in service, madam, office cleaning in the office of Director of Irrigation Division.
So you have been asked to produce relevant documents. You have produced it.
My lord, accept annexure 6 and another representation, my lord, 9 annexure, page 26. I am working to the, my lord. It is also information that some other outstanding money has been sanctioned in my name, my lord. Officials informed that if order is obtained from High Court,
Page number?
case number 26, my lord.
So, madam, you see, this annexer 3 of your affidavit. So, a letter was written by the director to the secretary for creation of new head of account. Whether this process was completed,
I'll have to obtain instructions.
and otherwise, what is your stand?
Okay, my sense that I have stated in paragraph number 4, your lordship, that he was initially, he has an appointed contractual basis, and for, lordship from 2000, from 3/10/2017 to 3/31/2018. Then later on, it was extended for another 6 months, your lordship, 1/4/2018 to 31/10/2018. Lordship, this phase we have not given him the remuneration, your lordship, which he accepts in paragraph number 5, your lordship. And this is the amount that we'll be paying to him, your lordship. And we have asked the authorities to give a sanction of it, your lordship. Otherwise, for the period which he has been claiming, your lordship, from 2018 to 30/10/2022, that period they are not liable because we have not asked him, your lordship. So only for the period from 1/2018 to 31/10/2018.
He is entitled to salary, his salary.
Period, your lordship. Otherwise, paragraph number 5, your lordship, we have stated. How the payment stated that the petitioner did not serve for the period with effect from 1/11/2018 to 30/10/2022. In fact, he had not been engaged by the office of the director of the secondary education for the period with effect from 1/11/2018, 30/10/2022 as he claimed for.
But his contention is that he has been working since then till today. Do you have any engagement letter thereafter?
Yes, my lord, and the next day
Pardon?
on the next date, if possible, I will bring and protest myself.
Next day.
Next day.
Okay. Heard. Mr. B. Hussain, learned counsel for the petitioner. Ms. D. Musahare, learned standing counsel for the respondent in secondary education department. During the course of deliberation, Ms. Musahare submits that the petitioner was
Paragraph 4.
engaged from one, no, petitioner was
Engaged on contractual basis, your lordship.
engaged on contractual basis with monthly remuneration at the rate of rupees 6,500 with effect from 3/10/2017 to 31/3/2018. And for the aforementioned period, he has been paid paid his remuneration at the rate of rupees 6,500 per month. Thereafter,
And any
There
other-
was extension, my lord, for
Thereafter,
further period.
his service was extended with effect from 1/4/2018 to 31/10/2018. But for the aforementioned period, the salary could not be paid on account of
Lordship, for the period 3/10/2017 to 3/31/2018, that amount has already been given to the petitioner.
yes, yes.
That amount was given.
Thereafter, he was again engaged from 1/4/2018 to 31/10/2018. And for that period, you could not make
Yes,
payment of the amount,
Yes, yes.
payment of the account. Yes. The Yes, creation of a new head of account is required to make payment of wages of regular wages of contractual employees. And to that effect, one letter has been written by the director of secondary education to the secretary to the Government of Assam Department of School Education for creation of one head of account. But the instruction in respect of the outcome of said letter is still awaited. Ms. Mosari further submits that though claimed by the petitioner, he was not engaged from 1/11/2018 till 30th/10/2022. But Mr. B. Hussain, Learned Counsel for the petitioner, submits that he will produce relevant document of engagement of the petitioner by the respondent authorities on next date. Accordingly, it is provided that the list the matter, SSL list the matter on
On 10 December,
10th of December. On that day, Ms. Musari shall obtain the status report in respect of the letter dated 21/1/2025, written by the Director of Secondary Education to the Secretary to the Government of Assam Department of School Education. List accordingly.
turning under 5.
Obliged.
Maybe. The instruction, my lord. They have admitted the date of retire compulsory retirement 1/1/2011.
Hmm.
The post-retirement benefit will follow from that date only.
Hmm.
That will be.
So now we will close the petition.
Instead of closing, I will dispose of it.
Okay. We dispose of the petition. In view of the instruction produced today.
Your lordship will clarify the regarding entitlement. And
Pension and pensionary benefits as per his entitlement.
obliged.
Item number 7 and 8, partner matter. This matter, a detailed report has been sent in item number 7 losses. A detailed report has been sent to the secretary losses for national guidelines losses. So now the secretary will. report was sent on 15/11 losses.
When?
15/11. The day before yesterday losses. Therefore, losses are fixed the matter after 3 weeks losses.
So now you are agreeable to pay the great pay at the rate of rupees 6,200.
Lordship, if you lordship.
What was your claim?
But our claim was graduate skill melod who are completed the trained graduate teacher. They are entitled 8,700 melod. And who are graduate trained undergraduate, they are 7,800. Our claim melod. Already we have received, but by the impugned order, that entitlement was stopped by the treasury officer. We have already received an amount on the basis of the enhanced grade pay, that is the graduate training teacher. But
At what rate?
Malad,
At what rate?
Malad, as per eight graduate teacher 8,700
Hmm.
we have received. Another my lord, trained undergraduate 6,800.
No, you do one thing, you go through this instruction received by him.
Malad, I have gone
My friend has already seen.
already said, my prayer is, my lord, let them bring instruction from the government whether we are entitled or not.
It will take 3 weeks.
Just this is the report sent to the government, my lord,
Hmm.
whether we are entitled or not. This is the
3 weeks loss.
Okay. Heard Mr. R. Islam, Learned Counsel for the petitioner, and Mr. P.N. Sharma, Learned Standing Counsel for the respondent in secondary elementary education department. During the course of deliberation, Mr. P.N. Sharma has produced one letter of the Director of Elementary Education addressed to the Secretary to the Government of Assam, requesting necessary guidelines and instruction in respect of the claim being made by the petitioners in this petition. And on the basis of the said letter, Mr. Sharma submits that since the letter was sent to the Secretary to the Government of Assam on 15/11/2025 only, the matter may be listed after 4 weeks so as to enable him to obtain up to date instruction. Where allowed, recess and list the matter on no, sorted. Before vacation?
December.
7, 8 is also same.
Same, my lord.
Your Lordship, I think after some time being, Mr. R.C. Soikia, senior advocate.
It will come up after which the matter was.
After?
Fixed after 6 months.
Why?
But this matter has come up for the first time after the matter was fixed for 6.
No, you have already argued the matter before the earlier bench.
Yes, madam. Long back, madam.
Maybe.
You need to prepare my once again, madam. And in our actually that's we have asked the clerk to start the file.
Mr. R.C. Soikia will be coming, he wants some time after. Or
No, maybe,
being.
but if they're not prepared, his presence will not make any sense.
Okay. Then after 1 week, for
After-
hearing.
After 1 week.
Kindly keep it open to this. I am
Okay.
appealing this matter for October 7. Let it come after 2 weeks, date when we get after decision.
After 2 weeks. Heard, Mr. Your name,
Second,
Your-
JP Borua on behalf of. Okay.
learned counsel for the petitioner, Mr. S. Das for respondent number.
Higher education.
Respondent in Higher Education Department, Mr. Diener, learned senior government advocate for the respondent number 7.
He is a private respondent, principal of the college. I mean.
Oh, private respondent, okay. Mr. Diener for the respondent number 7. 4 to 6. Any other? You? Respondent number 8. On the pair being made by Mr. S. Das, learned standing counsel for the respondent in Higher Education Department. And also on the pair being made by Mr. Diener, learned counsel for the respondent number 7. Recessal list the matter after 2 weeks.
It may be fixed, your lordship, on COVID. 9th of December.
9th of December.
Bless your lordship.
And number 10.
May it please your lordship, my lord, this matter was heard, my lord, at length, my lord, and thereafter it was fixed judgment. But my lord, meanwhile, the petitioner was, my lord, superannuated. And the term of the, my lord, post was for 5 years. That has also been completed.
Now,
Now it's become infectious.
infectious.
The post is Director of Students Welfare in Cotton University. That it's a term post for 5 years. The term was over on 6th of October this year.
Okay.
My records are there. Original records.
Oh, okay, you can take the record.
Fine.
Heard, Mr.
Yes, sir.
N. Sarkar, learned counsel for the petitioner, and Mr. P. D. Nair, learned counsel for the respondent number 2, 3, 5, and 6.
Fine.
And Mr. Sodhuri for respondent number 4.
That's not for that. I'll be paying for 1 month.
And Mr. Das, learned standing counsel for the Higher Education Department for respondent number 1. The learned counsel for the petitioner submits that the petitioner has already superannuated on
My lord,
31/10.
yes, my lord, on 31st of June, 30 June of 2000, my lord,
30th June of 2025. And as such, this matter become infractious. And accordingly, he submits that the matter may be closed. Accordingly, taking note of submission of learned counsel for the petitioner, this WBC stands closed. Mr. Nair, learned counsel for the respondent number so and so submits that he had earlier filed the original documents, produced the original documents before this court, and he submits that the receipt may be directed to return the same. Accordingly, it is provided that receipt shall return the original documents produced by Mr. Nair before this court. Forthwith.
Item 11.
Lordship, my senior engaged revision lex. Lordship, मैं कल पास मेरा पूरा timing lordship.
Pardon?
My revision lex lordship.
I'm appearing for respondent number.
You will be
Lordship,
able
pass
to
over time.
appear today?
Lordship.
Will appear today?
Yes, lordship. For the timing lordship.
Okay.
Item 12.
Lordship, matter may be taken up some time. Mr. Bhua is on leave.
Item 13.
This matter was unfortunately reserved for judgment on 25th of September last year. The judgment could not be, all the arguments and are on record, my lord. The written arguments and everything. The matter relates to admission into Polytechnic Institute of Assam for students who underwent ITI, who passed ITI.
No, now you tell me, are you ready to argue the
Yes,
matter or
I'm
not?
ready, ma'am.
You are ready?
Yes, ma'am.
From our side, little accommodation.
Mr. Hart,
Can it be on
Mr.
Friday, my lord, coming Friday?
No, okay, all right. Hart, Mr.
T Chakraborty, my lord.
D. Chakraborty, learned counsel for the petitioner, Mr. S. Das, learned standing counsel for the respondent in higher education department. Mr. Pathak for respondent number 5. Mr. Das, learned standing counsel for the respondent in higher education department. Press for listening the matter on Friday
Friday, my lord.
After next week,
after a week. Fair allowed races and list the matter on next Tuesday
My lord, Tuesday.
prior to that.
Thursday. Lordship, on 25th, I have other matters fixed before your lordship. So
When?
on 25th, other matters are coming up before your lordship. It will be on 27th, definitely.
27.
27th. 25th, other matters are already fixed, my lord, not 25th.
No, this is connected matter or
No, my lord, separate matters.
separate? matter?
Yes.
Item 14.
My pleasure, Lordship. Lordship, my senior is now out of station, my lord, for his medical treatment, my lord. So matter may be fixed after 2 weeks, my lord.
After 2 weeks.
Yes.
Data lordship is partly to COVID solution of subjects. We are fighting for 2005. Data will not be the election of the other. Rather order has passed the order lordship setting aside that is provincialization and direction was given to provincialization subjects. And despite of that lordship order, that order is under challenge. And despite of that lordship, the authorities are releasing salary in this area. Now, mostly repeat date lordship. On the other hand, lordship, the lordship responded.
No, I am ready to hear the matter. If you are not ready, what can I do?
Yes, lordship, that's what I submitted.
Hmm.
It is several, but it is a part of matter. So then the-
No, no. Without hearing the matter, how can I keep it as parted? Okay. As agreed by learned advocates of both the parties, races and list the matter on coverage. Can it be on 25th or before? 27th. 27th.
Item 15.
Number 17. Okay. May I please?
Yes.
Lordship, who and number 6 has filed affidavit. And the remaining respondents there to file affidavit. Last order.
Within 2 days. So the matter has to come up after
Look,
a week.
date may be fixed because they are all retired persons. They are,
Okay.
and respondent number, we can't find it.
3 and 5.
Then 1, 4 and 7.
Since when? No, your instructions are awaited since when? No, how many adjournments you have already availed?
Yes. Notice was issued on 10/4/2025.
Heard Mr. S.K. Sharma,
Yes, Ketan.
learned counsel for the petitioner. Mr. D. Nath, learned counsel for the respondent number 3 and 5. And Mr. Your name please? C? Learned counsel for the respondent number 4 and 7. 147. And you? 2 and 6.
2 and 6 has already filed affidavit.
Already filed affidavit. Okay, Mr. D. Nath, learned counsel for the respondent number 3 and 5. And Mr. Paul for respondent number 4 and 7. Press for granting 1 week time to file their affidavit in opposition. They are allowed recess and list the matter after 1 week.
Can you date may be fixed?
Correct.
Obliged.
Item 16.
May I please, your lordship? Basically, in the writ petition, my lord, we have challenged an order of transfer. My lord, what has happened, my lord, during the pendency of this writ petition, the petitioner had been working in his original school. Though he initially joined, my lord, but he came back and rendered his service in his original school. So, my lord, as the petition is pending, my lord, the department being aggrieved, my lord, with the non-compliance with the order of the authorities, my lord, as I have been again come back to my parents' school. They have, my lord, recently stopped my salary. Last 4 months, my lord, I am without any salary, my lord. That's why my lordships on the last occasion wanted to know from the department that under what provision of law the salary has been, my lord,
Okay.
detained, my lord.
Mr. Sharma, that instruction is available with you.
Next week, in fact, on the last occasion, the lordship see the order letter 21, 29, 25.
What treatment?
My learned friend was supposed to they got certain new development, my lord.
No, yes, my lord, that we file an affidavit, how the department is dealing with us, my lord, that is not on record, but prior to that order, there is earlier order. My lordship wanted to know from the department, my lord, that why my salary has been, my lord, detained, my lord, and it is also, a letter is also on record, my lord. I have forwarded, my lord. So, my lord, if my salary can be released, my lord, at least I have child, my lord, school going children. I am discharging my duties in the parent school also, my lord.
Lordship fixed next week, lordship. That instruction, regarding the salary.
No,
It is a coercive action, my lord. It is a coercive action without any provision, my lord.
Order was passed on 10/9/2025.
My lord, my lord. On an order of, my lord, 26/8/2025, my lord. That letter, my lord, it is perhaps it is a part of the record, my lord. That letter, my lord.
Next week.
No, by next week you have to produce before this court the order of payment of salary.
My lord.
You have to ensure payment of salary.
I will get the instruction.
Heard. Mr. A.R. Bhuya, learned counsel for the petitioner. Mr. P.N. Sharma, learned standing counsel for the respondents in elementary education department. Referring to the order dated 29/10/2025, Mr. Bhuya submits that in respect of the development that had taken place, he will bring on record the same by filing an additional affidavit and a press for granting him 1 week time where is allowed. Further, drawing the attention of this court to the order dated 10/9/2025, Mr. Bhuya submits that the learned standing counsel for the respondent number 1, 2, 4, and 5 was directed to obtain instruction as to under what provision of law the district elementary education officer Pujai has directed the block elementary education officer to held up the salary of the petitioner. Mr. Sharma, however, submits that instruction is not available to him, though the order was passed on 10/9/2025. Mr. Bhuya submits that the petitioner has been facing immense hardship due to non-payment of his salaries, and he has school-going children also. And under such circumstances, it is provided that Mr. Sharma, learned standing counsel, shall ensure payment of salary to the petitioner with effect from
Lord,
from which month?
my lord, it was from August 1st of August 2025, my lord.
1st of August 2025
My lord.
till date. Place the matter on fixed date. A copy of this order be furnished to Mr. Sharma to comply with the directions of his during the course of the day.
Well, so grateful, my lord. Deeply obliged, my lord.
13.
May I please, your lordship. This is, my lord, the withholding of annual increment, my lord, with cumulative effect of the disciplinary proceeding, my lord. Already notice issued, my lord.
Instructions sometime in the
You are appearing for
for all the respondents.
all the respondents. Heard Mr. C. Goswami, learned counsel for the petitioner, and Mr.
A.K. Ghosh on behalf of Mr. Keko.
A.K. Ghosh, learned counsel, appearing on behalf of Mr.
Keko.
K. Kumar, learned additional advocate general for the state. And madam, you are appearing here? No. The learned counsel for the respondent authorities. Price for listing the matter after a week.
Should 2 weeks and be.
After,
Date may fix, my lord, in the meantime.
after 2 weeks, so as to enable them to file their affidavit in opposition. There is allowed recess unless the matter on 5th December.
Obliged.
Item 18. We have received that instructions in office. We have received them. Would like the final answer.
You have received the instruction.
My lord, what has happened, my lord? This is a, my lord, challenge to a, my lord, selection and appointment has been recently, the TETCOM recruitment, my lord, had been carried out. The petitioner before my lordship is aspirant for the post of science graduate teachers, my lord. Now, my lord, what has happened? Our post, my lord, has been occupied by a batch of, my lord, teachers who is eligible and qualified to apply for mathematics post. Now, what the, my lord, provision under the advertisement and the subsequent addendum, my lord, which they have made, given the double advantage to this, my lord, mathematics, having those candidates who has the honors in mathematics, my lord. As a result, my lord, what has happened? They have also come in our, my lord, area and occupied us and ousted us on very narrow margins, my lord, 0.75 or 0.25. Now, my lord, as per the instruction, my lord, more than, my lord, 2,000 posts are still lying vacant, my lord, in the entire, in different categories, my lord. Now, for the science graduate teachers, my lord, what is the cutoff date they have fixed? My lord, nothing is transparent, my lord. So therefore, we are in darkness. That what is the last candidate for the science graduate teacher, my lord, who had been selected? What was the last cutoff marks, my lord? Those things is not made available.
Okay,
My
let
lord.
them file their affidavit.
My lord, but my lord, may I pray, my lord, as these some posts are lying vacant, so without the leave of my lordships, my lord, those posts may not be filled
No,
up, my
no,
lord.
first, let us see their affidavit.
My lord, my lord.
Heard Mr. A.R. Bhuya, learned counsel for the petitioner. Also heard Ms. D. Musahari, learned standing counsel for the respondent in secondary education department. Ms. Musahari submits that she has received the instruction and she will bring the same on record by filing an additional filing affidavit in opposition. And price for listing the matter after a week.
After 2 weeks.
No, 2 weeks.
Some further instructions.
That affidavit is almost ready, my lord.
Lordship, Lordship, we have the instructions, but we need some further instructions from it. Your Lordship.
Okay, after 10 days. Okay, so what?
27.
My lord.
Obliged.
Item 19.
Lordship, in this case, what happened, Lordship, on the last order, Lordship, inadvertently, Lordship, notice was not issued against the private respondent, Lordship.
Notice was not issued.
Lordship.
Okay.
Yes, Lordship, please issue notice to the private respondent, Lordship. This is not fair now, it's Lordship.
No, you come to paragraph number 4 of the order. Here it is stated that issue notice returnable on 17.
Notice was issued, but no steps, there is no direction to notice the private respondent, Lordship. Without private respondent, Lordship.
Okay. Heard Mr. Upadhyay, learned counsel for the petitioner. And also heard Mr.
I got
learned counsel appearing for
1, 2, and 3.
1, 2, and 3. 1, 2, and 3.
4 also.
And for
Four.
Yeah.
Mr. Goswami for
2 and 7.
2 and 7. The learned counsel for the petitioner submits that though there was a direction for issuance of notice, yet there was no direction to take step against the private respondent. And as such, he applied for issuing direction to issue notice to the respondents, private respondents being respondent number 8.
Eight, Lordship.
Respondent number 8. Accordingly, taking note of the submission of learned counsel for the petitioner, it is provided that step upon respondent number 8 be taken by registered post with ADN also by usual process within a week from today. Justice service,
Lordship. Both
additionally, justice service is also permitted after effecting service by dusty mode upon respondent number 8. The petitioner shall file one affidavit before this court. Rest shall list the matter after
3 weeks, Lordship.
After-
3 weeks.
after 4 weeks.
Lordship.
After 4 weeks. In the meantime, the state respondents may file their affidavit in opposition.
Obliged, Lordship. Obliged.
I don't know.
My lord, I'm sorry, I was not, I was on Lake Shinana, the court when the matter was called, my lord. Now, an affidavit has been filed today by the, my lord, private respondents. I need to, my lord, respond to that. Your lordship will grant me time to file, my lord, the affidavit of the private. Today, my lord, copy has been served on us.
Okay. Heard Mr. M.K. Sodhuri, learned senior counsel assisted by Mr. Miss N. Dr. learned counsel for the petitioner. And Mr. B. Prasad,
10 to 24.
respondent number 10 to 24. Mr. Nath for 1 and 4. You for? A.K. Sharma, learned counsel for the respondent number 5 to 8. Who filed the affidavit?
10 to 24, my lord. That's for numbers 10 to 24.
10 to 24. Mr. Sodhuri, learned senior counsel for the petitioner submits that the respondent number 10 to 24 have filed their affidavit in opposition, and the petitioner will file his reply, and he prays for granting him
4 weeks time.
4 weeks time. Prayer is accordingly allowed. Rest is the matter after 4 weeks.
My lord, one further point, my lord, BTC has submitted, my lord, that they are not going to file affidavit. That can be recorded, my lord. My learned friend made a submission that they are not going to file an affidavit. No, my lord, if they file, my lord, let them say that they will be filing. Will you be filing affidavit? Please report whether you will be filing or not.
Okay. The learned standing counsel for the BTC prays for granting some time to obtain instruction in respect of filing of the affidavit in opposition. Prayer allowed. Rest is the matter after 4 weeks.
Obliged.
Lord, I am sorry, my lord, I was on leg, my lord.
Okay.
My lord, the matter relates to, my lord, petitioner is, my lord, praying for her reversion from Lien to her original post, my lord. She was, while working as a, my lord, lecturer in the Diet, my lord, Hailakandi, she offered an intent to go for a better job opportunity, my lord, as a medical social worker under the health department, my lord. So for that, she did apply, my lord, for granting Lien leave. And accordingly, my lord, the authorities initially issued the no objection certificate also to allowing her to go and migrate in the health department, my lord. But of late, my lord, when I, my lord, applied for to revert me back by way of an impugn order, my lord, kindly turn to page 58. my lord.
No, whether they have filed their affidavit.
No, my lord, that is the difficulty. No affidavit till date, my lord. No, anyway, department is not filed.
Also, here, SCRT.
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 Sorry for sir.
You have received instruction Heard Mr. A.R. Bhuya, learned counsel for the petitioner, Mr. P.N. Sharma, learned standing counsel for the respondent. Respondent number 1 and Miss A. Borthakur, learned counsel for the respondent number, appearing on behalf of Mr. P. Nayak, learned standing counsel for the respondent number 2 and 3.
There are two is the principal, my lord. My learned friend is appearing for 3, my lord. And the principal we have taken Dusty and my lord, we have also filed an affidavit. Service is complete, my lord. And
Mr. Bhuya, learned counsel for the petitioner submits that after effecting service upon respondent number 4,
my lord.
the petitioner has already filed an affidavit to that effect and assert service upon respondent number 4.
No,
Has
respondent 2,
already-
my lord. Respondent 2, my lord.
Respondent number, no, she has been appearing for respondent number 2.
3, my
3,
lord. 3, my lord.
not 2.
My lord. 2 we
Okay,
have
2.
step, my lord.
Oh, and as such, service in respect of respondent number 2 is then completed. Ms. Borthakur submits that she may be granted 3 weeks time to file affidavit in opposition. Where allowed, rest shall list the matter after 3 weeks. Bobby.
My lord. Pleasure, my lord.
Order number 45.
Other side is not there. Other day made my submission, my lord. No show cause was issued before the proceeding was draw up, your lordship. Also, he was placed in a suspension, my lord. It was reviewed. My lordship wanted to know whether any ground has been cited in the order of review. Probably this suspension order would go because current proceeding was drawn up in violation of procedural mandate, no show cause. And the disciplinary authority is lower than the appointing authority. Here, yes, on these 2 grounds, but liberty should be given to us. He's absent. Lordship should have submitted.
After some time, let him come.
Yes. Lordship will kindly accommodate, I may be in some other.
Okay,
mode.
all right.
Item 46.
Lord, please, your lordship. So for the day, lordship, to
Pardon?
pass for the day, lordship.
Passed over for the day. Heard, Miss? Learned counsel for the petitioner and also heard you are appearing for
For MSA for CGC, learned CGC.
A. Fukon. Learned standing counsel for the respondent in elementary education department. The learned counsel for the petitioner submits that the matter may be adjourned for the day. They are allowed.
Date may be fixed any
Let's
day.
just list the matter on Bobby.
8 December. Order number 47 to 50.
Please, lordship. Item 47 to 50 may be passed over for time being, my lord. My civil counsel is in port number 4. Exit port number 4.
Pardon?
My civil counsel lacks in care port number.
Okay.
Order number 24 orders.
Your lordship. I may be allowed to some time, my lord. Petition in the condemned in the resultant vacancy caused by the retirement, superannuation, and death, my lord. During the pendency of the suit, my lord, all the respondents have been impede them, my lord. So I may be allowed to file a petition impeding the new, my lord. But my lord, at the time of filing, my lord, WC, my lord, our prayer was, my lord, last to send for training, my lord. Finance department was not necessary party, my lord. After passing the order on 4, my lord, salary finance department is also necessary party. So I may be allowed to make them, add them as a party, enabling them to take their own stand, my lord. All 5 respondents.
Otherwise, all that has been complied with. He has been given place appointment, my lord, and he accepted the place appointment.
I will submit that one.
Okay, okay. Heard Mr. Ahmed, learned counsel for the petitioner, and Mr. Khatonia for. Khatonia, you are appearing for?
Like, my lord, I am not actually representing any other respondent here, my lord. I'm just representing the department, my lord, here, because I have to.
Learned standing counsel for the department. Department. Mr. Ahmed submits that he may be granted some time to implement
The new incumbent, my lord,
incumbents
that's one of 1 to 5.
in place of the earlier respondents, stroke contemners. Where allowed recessal is the matter after.
Along with the finance department. Earlier, my lord, when the WPC was filed, my lord, that it was a not necessary party. After
No,
passing
no,
the
if you think that finance is a necessary party, you have to file one interlocutory
petition.
application.
Yes, obliged. Lord.
List the matter after 4 weeks.
Obliged.
21.
Maybe. The last order, 24, my lord. The evidence. It have filed affidavit.
You have filed your affidavit.
Yes,
When?
but that in the meantime, they have filed not, my lord. And respondent number 1 and 2. It's not in the simply the new incumbent, my lord, 1 and 2.
You have implemented them.
Yes, my lord.
When? When?
We'll file a IA, my lord.
When? After 4 weeks.
Yes, my lord.
Okay, Mr. Khatonia, you were again for the department.
Again, for the department, here also my order has been compared to place appointment.
Okay. Heard Mr.
Behalf of Jay Barbuya.
A. Hussain, learned counsel,
Hussain,
appearing on behalf of Mr. J. I. Barbuya,
Yes, my lord.
learned counsel for the petitioner, and Mr. Khatonia, learned standing counsel for the department. The learned counsel for the petitioner submits that he may be granted 4 weeks' time to implement the new incumbents as a respondent contender here in this petition. Where allowed, recessal is the matter after 4 weeks.
Of last minute.
22.
Even instruction open you are you sir? May please also. Method listing payment of salary, my lord. This 60, 17 is the, my lord, order of this honorable court, my lord. Right.
Here also, my lord, place appointment has been given to the petitioner.
Take it as written, First John.
No, Mr. Khatonia. So press appointment you have given, no problem. But what was the direction of this court?
While they have accepted the place appointment, they have given an undertaking, that they will forgo their previous case.
Before filing of this contempt petition or after?
After filing it. Because the decision was taken in the year
21.
2020, madam. Every decision was taken, madam, and appointment was offered in the month of
January 21.
October 2020, madam.
October 25,
October 2020.
2020.
Because all are the appointees of MRG, madam. They are subject to the screening process. And in the screening process, madam, they have been identified as irregular, but they are working. So a decision was taken to accommodate them.
No, that illegality, my lord, in the order itself reflected that that is not the correct fact. Because the earlier termination order, that this honorable court has set aside that order. The page 17, my lord. Illegality, but appointment against my lord
non-existent posts that have been held by this honorable court, my lord, page 17.
There are other similar matters when they accepted the appointment order, my lord, this honorable court was pleased to close those contempt, my lord. There are several orders from this honorable court, my lord. Whoever accepted the appointment order with the condition that they will forego their past claims, this honorable court was pleased to, my lord, close those contempt, my lord.
What is those orders?
Yes, my lord, I yes, my lord. And in any case, my lord, here the earlier incumbent, they have audited data from service, my lord.
Paragraph 17, my lord, last paragraph, a perusal of the order dated 27 March 2014 would leave no matter of doubt that the petitioners were treated to be terminated teachers having been existence posts. The assumption and conclusion of the director that included in list of terminated teachers is considered by the Learned Standing Council for Elementary Education to be unfounded, having not been borne out of record. If that be so, the entire decision-making process is vitiated, and therefore I have no hesitation to set aside the order dated 27 March 2014 issued by the Director of Elementary Education. That part, my lord, that stand, my lord, is not sustainable at this time.
I'll produce those orders, my lord. There are several orders for the from this honorable court.
And what to do? You have to implement the new incumbents now. You take a step. Heard Mr. Sharma, Learned Counsel for the petitioner, Mr. Khatonia for the department. Mr. Khatonia has pointed out that the respondent contender here in this petition has already retired from service, and as such, and in their place, a new incumbents have already assumed their search, and as such, the new incumbents are required to be implemented as party in this proceeding. Mr. Sharma submits that he will take necessary step. Mr. Khatonia further submits that the petitioners of the present contempt petition have already been accommodated as tutor or teacher.
My lord, 22.
22.
That my lord. That has not been mentioned in the communication, my lord.
Already been accommodated.
Subject to their qualification, my lord.
Already been accommodated subject to their qualification, and they have given an undertaking to the effect that they will not make any claim
For their
regarding
past
their past services. And on the basis of aforementioned position, several contempt petitions have been closed by this court, and he will produce the said orders before this court on next date. Accordingly, it is provided that recessal list the matter after 2 weeks or
4
1
weeks,
week.
my lord.
2 weeks.
4 weeks, my lord.
4 weeks. Okay. Okay. Okay.
Obligement.
Item 23.
It is also same, my lord.
Same. But nobody
Yes, my lord.
for the petitioner, none appears for the petitioner on call. However, Mr. N.J. Khatonia, Learned Standing Counsel for the department present, lays the matter after 1 week.
24. Might be granted to implement party, new incumbents.
Okay. Heard Mr. A. Gohai, Learned Counsel for the petitioner, Mr. Khatonia for the Respondent, department, for the department. The learned counsel for the petitioner submits that he may be granted 4 weeks time to implement the new incumbents. Where is allowed, recessal is the matter after 4 weeks.
25.
None appears for the petitioner on call. However, Mr. Khatunier for the department present list the matter after 1 week. It appears that this matter was earlier listed on 2/12/2024, and on that day also the petitioner remained absent. Today also the petitioner remained absent without any steps. No, petitioner remain absent. Petitioner remain unrepresented. In the event of subsequent non-representation of the petitioner, appropriate order shall follow. Recessal less the matter after 1 week.
Item 27.
No.
Lordship. With non-compliance of order dated 16/2017, Lordship. In WPC number 5342/2015.
Oh, respondent number 5 and 6 have been completed later on.
Later.
You have taken a step upon them.
I have taken. Will be taken, Lordship. Press step may be taken, Lordship.
Press step. Okay. Heard, Mr. Your good name, please.
P. Buregi.
P. Boregi, learned counsel for the petitioner. Mr. Khatunier for the department. Office note dated 12/8/2025 indicates that neither ID card nor unserved notice in respect of respondent number 5 and 6 received by the section till date. The learned counsel for the petitioner submits that he may be allowed some time to take fresh step upon respondent number 5 and 6. They are allowed recessal is the matter after 4 weeks.
Lordship.
After 4 weeks.
Lordship. 28 and 29.
In item 28, my lord, I am praying for a little accommodation for today, my lord. Unfortunately, this is my brief, my lord. That is why
Concept petition was filed against the learned single judge judgment, and thereafter, a learned single judge judgment was dated 28/11/2018, which was upheld by the Honorable Division Bench. And now 2024, they have filed the review petition against the judgment of the learned single judge on the pretext that the 2011 Act has been declared ultra vires. On that, your lordship have filed, also dismissed a review petition. The same issue, your lordship. Your lordship. Same issue.
No, not in this petition.
Not in this. On the similar issue.
Okay, let him argue on a
any date, my lord,
different day.
any date, my lord.
Let it be on Friday, my lord. I am very much hard pressed, my lord.
Okay.
On Friday, my lord. It is
Heard,
our-
Mr. Khatunier, learned standing counsel for the secondary education department. And also heard, Mr. Your good name, please.
M. Chandra. M. Chandra.
M.
Chandra. States.
Okay. Learned counsel for the respondent. Mr. Khatunier, praise for listening the matter. After a week, pair allowed recessal list the matter on Friday then?
Yes, my lord.
Oh, right.
21st.
21st. Numbers 30 to 37.
What's this? We peruse the last order. Huh? Division. What's about division? কিন্তু ক্লোজ নকৰো দেই এপ্ৰুভেল হে হৈ যাব লাগে না
Approval has been given for payment of current and area salary, my lord.
When they will get the same?
well, make it at least 15 days time, my lord, because
15 days time. So do I dispose of the matter?
No, 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 my lord, it is pending here, but because it is approved by the
Pending.
finance department.
Okay. Heard Ms. K. Devi, learned counsel
It
for
is
the
not yet
petitioner, and
completed.
Mr. Khatunier, learned
15
standing
days
counsel,
recommending.
learned counsel for the contempt. Counsel for the contempt notice. Mr.
Hmm.
Khatunier has produced one letter, which is the relevant letter here.
first one, my lord.
Produce a letter of the director dated 16/11/2025,
5th December.
addressed to the Senior Standing Council, Department of Education, Guwahati High Court. And on the basis of the said letter, Mr. Khatunier submits that the respondent contemnors have already given approval for payment of the arrear as well as current salary of the petitioners. And he prays for listening the matter after 2 weeks.
My lord, may it be taken on 5th of December, my lord.
5th of December, my lord.
Okay. Prays for listening the matter on 5th of December. Pair allowed recessal list the matter on 5th of December. The letter produced before the court today shall be marked as annexure X and be tagged with the record.
Okay.
Numbers 38 and 39.
As per last order, Director of Trade of Management was speaking.
Your lordship, item number, lordship, I need some time. I'm speaking with the official. Lordship, they are having difficulty to find the proposal, lordship. So lordship may fix it. I've questioned my friend also, if lordship may fix it on Friday, I'll be in a better position to give an update, lordship.
Okay. Heard Mr. Purkesta, learned counsel for the petitioner, and Mr. A. Soliha, learned standing counsel for the
Finance.
Finance department.
finance department. Mr. Soliha prays for listening the matter on Friday so as to enable this part, so as to enable him to produce the latest update upon the matter. They are allowed. Recessal is the matter on Friday.
On 21st November.
Bless.
Number 40.
40 letters also become in fact.
So they have
Already-
complied with.
No.
Okay. Heard Mr. L. Gogoi, learned counsel for the petitioner, and Mr. Khatunier, learned counsel for the contender. Learned counsel for the petitioner, Mr. L. Gogoi, submits that this matter become infectious as the respondent contenders have complied with the order of this court passed in WPC number 8156 of 2025, dated 22/1/2024. Accordingly, taking note of the submission of Mr. Gogoi, learned counsel for the petitioner, this matter stands closed. Obliged. Okay. We'll resume after 5 minutes.
Time.
So, you have given a copy to him? So when the matter can be listed then? After 2 weeks. Heard Mr. Polita, learned counsel for the petitioner. Mr. Decker, no, Mr. Bora for the respondent contender. During the course of hearing, Mr. Bora has produced one letter of the Undersecretary to the Government of Assam Department of School Education dated 15/11/2025, addressing the Director of Elementary Education Assam, Kailipura, Guwahati, regarding clarification in respect of appointment and service detail of Srimati Debo Gogoi in connection with that contempt petition. And Mr. Bora, on the basis of the said letter, price for listing the matter after 2 weeks. Fair allowed recessal list the matter after 2 weeks. The letter produced before the court today shall be marked as Annexer Z and be tagged with the record.
Items 42 and 43.
Second time.
But is there for 2 weeks, final. This is the department of the instruction. Process, sometimes.
Almost time unit.
But that will give me, 2 weeks. Get the updated status.
Weeks. Heard Mr. Your good name, please. S. Goswami, learned counsel for the petitioner. In both the matter,
No,
T. Soikya for petitioner in 258. 258 of 2025. During the course of deliberation, Mr. S. Das, learned standing counsel, learned counsel for the contender has produced one letter dated 14/11/2025 of the Secretary to the Government of Assam Higher Education Department, written to the standing council, informing that the matter is being processed in the higher education within bracket technical department. And as suggested by the finance department, the file has been moved to judicial department for views. And on the basis of the aforementioned letter, Mr. Das has prayed for granting him 2 weeks time to obtain up-to-date instruction. Pair allowed, list the matter on. Okay.
December.
The letter produced before the court today shall be marked as Annexer X and be tagged with the record.
I think about 51.
May please, your lordship. Petitioner. My lord, so my lord, he preferred independence of petition in this year after lapse of 1 year. Now, my lord, he filed is presented, but the
I received the instruction, I will file my request. This time.
Heard Mr. M.K. Das, learned counsel for the petition. And Mr. Goswami for the respondent number
1, 3, 4, 5, 6, 8, and 9.
1, 3, 4, 5, 6, 8, and 9. And Mr. Borova. Respondent number 7. You phone no. Mr. Goswami submits that he may be granted 2 weeks time to file affidavit in opposition. Pair is allowed for the last time. You have already availed several adjournment. List the matter after 2 weeks.
4th December.
4th of December.
And items, item number 2 and 3 for admission, partial method.
Item number
2 and 3.
1, 2. Order है sir. Order है to sir. 2 and 3.
The first, the 708515. The report not meant the DEO different PMs manner, but the DEOs made so that all selection process comes. The department to the government matter. The on 30th of November. They are asking for accommodation for today, Miller. And that may fix after a week. And the report from the full because it's a question of he was not appointed for the second formal selection was there. Exactly appointed. So there is more to it. They are asking for the salary is not simple. That the only I go to the
Yes. Have you seen the instruction?
I got it.
But my learned friend has one part of the story. Actually, the petitioners were appointed in the year 1994. They got 3 months salary each. Thereafter, commissions were held, including Monitoring Commission, etc. Separate petition was filed. And finally, and it's in our case 20 of 7058.
Yes.
Yes. 20, no, page 16, kindly first see page 16.
Yes.
In exercise of the power conferred upon the Director of Elementary Education Assam by the government, letter number so-and-so, that is so-and-so, and in person, the government so-and-so, that is so-and-so, cabinet meeting held on 24/2/2005. 276 numbers of LP, MD, MDM, HSS, HWS teachers of the state who were excess of post in the period 1/3/30. By the one-man committee headed by Sri S. Manoharan IAS and subsequently by task force, district level screening committee, departmental screening committee, 125 MV working teachers district are hereby regularized with effect from the date of their joining against the first list the government. So this order was passed after long drive, after long communication between the intergovernmental authorities. Now, can you say, page 17 honors the names of the teachers. Now, Kindly come to test me. Mine is pair number 118. And 123 is one Tulsi Burman. This Tulsi Burman has been paid salaries since the day of his challenge. He was also challenge with me. And one Hafizur Rahman, and his name Lordship may kindly see, second case. Hafizur Rahman, kindly see page 18. 48, serial number for Hafizur Rahman. So this post was also regularized. Page 18, serial number 48. And almost all of these teachers, 125 teachers, accepting a few teachers, have got their salaries from the day when their posts were salaries by the director. There are hundreds of irregularities. All irregularities have been demolished by the order of the director. Finally, as per government's order,
So this order is still in force.
still in, and all the persons, accepting persons, they have got salaries. And when the person was saving, serial 123, she is getting salary as usual.
Tulsi Burman.
Tulsi Burman. And this 48, Hafizur Rahman, he is getting, he has got the salary from the month of November 21. November 21, he is getting salary till today. Before that, he has not. So he has filed for arrears salaries. This is now from the day when he was supposed to salary. So it is not on record, but I have instruction that this November 21, Hafizur Rahman is getting salary. Same order. And High Court passed order on the same repeat. Now kindly see my book. Page 22. Page 22. Name of the parties, page 23. Salimuddin. And he is Hafizur Rahman. And common order is passed by the Honorable High Court. And that lordship may kindly sit. 32. Kindly come to first. There are 6. Counsel for the having had learned counsel for the petitioner and learned counsel for the respondent, and inclined to dispose of this contradiction by extending the period. Petition order dated 16/10/2010 provides implementation by a further period of 3 months from today. And implementation by the no appeal is filed by the respondent and no stay is obtained of the order issued therein. In other words, if filed by the respondents and if filed and yet is obtained, then order dated 63/2010 passed in shall have to be complied with letter and spirit. So can you see the wordings of the Honorable High Court? Letter and spirit. By the respondents within 3 months from the date of this order, if the order is not complied with, period, the respondents and all the compliance shall be held guilty of committing contempt of this court order and orders of imposing punishment as provided under contempt of court act which be passed against.
So the contempt proceeding was earlier filed and the same was disposed of, directing the. And since then, how many years elapsed?
Is so order was passed to 14. 11 years they are cited.
This matter, is the communication which are given. Let him complete and I will say.
They who satisfies them, he is paid. Who cannot satisfy, he is not. Because Hafizur Rahman is getting same case, same order. Tulsi Burman, same case, same order, same pronunciation order. But they are getting not only these 2 persons, many others are getting. And my lord, kindly see, since 2006, we are in 2025. Since 19 years, still I am not getting a single rupee. How pathetic is this? So there should
Let
be
him complete.
directly sent to jail because as per order of the Honorable High Court. Punishment it is clearly stated by the Honorable High Court that committing contempt of order, appropriate order imposing
No,
punishment.
Mr. Mahmood, you see that contempt petition has been closed. You ought to have filed one IA in that contempt proceeding.
Thereafter also I have filed.
Instead of
have also
this
filed-
IA, you have preferred this fresh represent on the fresh writ petition.
Because time was already elapsed. One year time was elapsed. So, but my right exists. Right is not extinguished, my lord, because I am serving. I am serving. It is a continuous right. By passage of time, with that it cannot be denied.
No. I am not saying that your right extinguished. But instead of reviving the contempt petition, in this writ petition, you have again made the same pair.
But they should pay. I should pay that. At least my current salary be paid. So that I may live like a man. They are taking from me forced labor. Current salary may be paid better. Lordship has said that we have very good case.
Lordship, if Lordship allows me, I can. My lord, in the Lordship, the letter which I have given. Letter which I have given, my lord, the communication. The Lordship comes to the second, so the paragraph, bottom of the second paragraph. It is observed, my lord. Kindly see, it is observed that the petitioner primarily agreed by the government's order dated 2014, my lord. 2014, my lord. And my lord, subsequent to this, my lord, wherein the petitioner was rejected, he already approached after this contempt. After this contempt, he had approached my lord and his claim was rejected, my lord. Kindly see, my lord. So this part which the honorable that part was only regarding the 10/1/2014 order, which was disposed of. That was already disposed of. Subsequent to that, he again approached me. It is observed that the petitioner is primarily agreed by the government's order dated 2012/2014 when the petitioner's claim was rejected, my lord. Can you see this? It was rejected again, my lord.
No.
Thereafter,
After
order dated
Mr. Fukon, you see, after the contempt petition being closed,
Hello.
directing you to release his salary. How can you reject his claim?
There, my lord, the department has, my lord, appropriate order must be given. That part is not in the petition.
No, whether that was the no. You see, what was the direction in the contempt petition?
After making necessary inquiry, my lord, can you see? Paragraph 3, it is given no doubt that steps for releasing areas like current salaries are better after making necessary inquiry.
Where?
At paragraph 3 of the, that is page 31. Paragraph 3, page 31 of the order dated 10/1/2014. After making necessary inquiry. Means, my lord, the other petitioners, after making the necessary inquiry, they saw that those people are fit to get. He was not fit to get. So the handle was given by the court to the department to scrutinize and to verify as to whether he deserves or not.
No, where it is mentioned.
Kindly see paragraph 3, my lord.
Read it.
By the order under consideration out of which this contempt petition arises, the learned single judge allowed the writ petition with a direction to the respondents to take necessary steps for releasing the area and current salaries of the petitioner after making necessary inquiry. After making necessary inquiry. It was not giving that release it in one instance. Directed that there should be an inquiry. That means something is there, my lord. That paragraph will not be added, my lord. That letter. So there is, my lord, that is why I am saying, my lord, there is more than meets the eye, because this person has been appointed, my lord, without any selection process. That is why, my lord, now the director, joint director has written to the secretary that because
No, no, after regularization of his service, where is the question of again verification of his service?
service, my lord, his name is not directly given there, my lord, because there were so many people, that time illegal, irregular people, my lord.
No,
Of
no.
course, is the order, it's at page 20.
No,
There
no,
is no specific direction of his name that he is being regularized. They've all sent, my lord. So his, even in fact, the.
no, no,
other thing
you
also-
come to annexure 2, page number 16.
Correct, my lord. Page number 16.
Hmm.
This order is, my lord, of whether he comes in it, my lord, where is his name in this?
Hmm?
Order is there, my lord, no doubt. I agree, to that extent. But
This
where is
order
his
is,
name in?
this order is still in force?
It is there, my lord, but after this, there was, my lord. So
Hmm.
lordship kindly sees, he himself has given that. The lordship says the letter itself. So without, he was 1994, without following any formal selection process, the petitioner received salary only 50. Subsequently, their service was recognized against non-sanctioned postmen. Therefore, my lord,
Non-sanctioned post.
non-sanctioned post, not sanctioned post. Therefore, my lord, I pray that this report should come.
No, no. You come to this page number 20.
20. 16. 20 is something else, my lord.
Yes, come to page number 20.
16.
Serial number 118.
My lord.
Vice Navakumar Roy, 80, retired.
Solimudi.
Hmm.
No, my lord, that we have seen at page 20. The lordship has seen that. That is the lordship comes to connection page 17.
No, no, then where is the question of regularization of his service again non-existent post?
Lordship, your lordship will again, I would request your lordship to kindly come to page 17 then. If
Hmm.
your lordship has shown page 20, please come to page 17.
Hmm.
17 is list of ME, MV school teachers of Ganga district proposed, man. It is
Hmm.
proposed. It is not been made. It is proposed.
Hmm.
That means it is given the names. At the same thing, this
Then,
is the same thing.
and
17 is
no,
but
no, no.
subsequently the service was regularized against non-sanctioned post.
That is cabinet decision dated 24 to 2005.
Kindly see the letter also. This letter also says the same thing. Yeah. Subsequently, the service was regularized against non-sanctioned post. Letter itself says it. We are not denying.
No, no, forget about that letter.
Well,
You come to page number 20.
well,
Is it non-sanctioned post?
going by this, my lord, you cannot say it is sanctioned or non-sanctioned, my lord. It is just a.
No, no, you answer my question. Is it a non-sanctioned post?
My lord, it's a district for proposed to be regularized. Proposed to be regularized by us.
Yes.
Is not, my lord, thing. So that's what I'm saying, my lord. It's that given a communication that this person was had joined without any formal selection process, and therefore, my lord, their
No, no,
they have contention with the other person.
After regularization of his service, you cannot raise the issue.
No, my lord, but there are other actions also, my lord. He has come, my lord, in the contempt, that contempt he is showing the contempt.
Hmm.
Contempt has already been closed. In this case, my lord, let this thing come, my lord, the report come regarding his case, my lord, because that will be crucial for the proper investigation. Because, my lord, Pandora's box will open otherwise. Pandora's box will open first. So these are, my lord, illegal, irregular, many cases are going on like this, my lord.
No,
And, my lord,
maybe going by this order,
Right.
you see, against, no, Vice Navakumar Roy, assistant teacher, retired. So against the post, he has been regularized.
My lord, kindly see again, I'm saying, my lord, 3 months of date of joining, subsequently their services were regularized against non-sanctioned post.
No,
Subsequent to that, later the
no,
petitioner applied for
Mr. Fukan,
Lord.
to substantiate that he was regularized against non-sanctioned post,
My lord.
where is the document?
Then I have to get instruction, my lord, regarding that. Let
Your
me get-
instruction will never come then.
Let me get, my lord, because this is an old matter, my lord.
Hmm.
And second, my lord, will kindly see, after they have given regarding the subsequent services were regularized against non-sanctioned post, later the petitioner had applied for.
No,
screening process.
this facts mentioned in
My
this
lord,
letter, not born out of the any record.
my lord,
You produce the relevant file on what basis this person has written this Facts. You produce the relevant file on next then.
My lord, two replies, got replies. For a moment, lordship kindly come to page 16. In exercise of the power conferred upon the director of jurisdiction by the letter number censor. The government has authorized the director, number one, and in persons of the government, order number so and so, dated so and so, issued on the decision of the cabinet meeting held on so and so. The cabinet meeting is has also authorized him for regulation of so and so, so and so. So now, kindly see after 5 days, 125 ME, MB, so and teachers of Bongaigaon district are hereby regularized. Regularized. With effect from the date of the joining against vacant post as enclosed in the list. This is the enclosure. That the list which I have enclosed. List received from the government. From the government. And government prepared the list after thorough inquiry. Now, my lord, my submission is this. Honorable Supreme Court issued several judgments. If you worship desires, I may produce it. If the opposite party, a PP or government advocate, argues something which is beyond record or which is not acceptable at all, then court shall take the matter seriously, because it cannot be a hindrance on the part of the government lawyer to get a salary by a working person. That is also there, that court will stop him immediately. You are submitting beyond record. And because justice, court will provide justice. That is the fundamental thing of the court. That's why people come to the court at the last hope of their shelter. So if such type of submissions orally against their record, in 94 it's true. In 94 I was appointed, but they say I am illegally appointed. That is not also illegally appointed. For a moment I draw your lordship kind attention. See, first appointment letter, page 15. Page 15 can listen. As per approval of advisory board and subject to charge without notice and reason thereof, is Solimuddin DA asked BJP as appointed against the newly created post so, and it was appointment order issued by Sri SP Brahmo Padgiri. It is their officer. Even then, since then 1994 till 2006, I have forgotten my salary. Yes, let it go. Let me get the salary presently after provincial election. But they are also not giving this. Some persons they pick up and they have been given.
Let me get me the record, I'll place it for the next year.
And 2015 they are getting instructions. 2015 they are also getting instructions.
Mr. Fukon, you see, this order annexed to page number 16 is still in force. By this order, the service of the petitioner has been regularized against one retired teacher. Right? Then on what basis this contention has been made in this petition?
But you will allow me that much of thing, I'll get my instruction, that much, since they are given, they have inquired and found something, otherwise they will not give unnecessary.
No, you
Once you will
see,
give it next
there
time, we'll bring it.
there was a direction of this court, and in the light of this order and the list and the cabinet decision and the order passed in the contempt petition,
Petition is disposed,
dispose of that, all right, you have not complied with.
But the contempt petition should have been this thing,
Pardon?
It should have come that time only, also yourself said,
No,
There was no
maybe
advance order
because of absence of advice, they could not file the contempt petition again.
Therefore, let me get the record, I will therefore place it before your lordship. Then lordship, it will come out properly. It will be crucial.
Mr. Mahmood, the order of the government dated 28/12/2014 is part of the record here. The order dated 28/12/2024.
2014, 2012, 2014.
Yes, Lordship.
Hmm.
Oh, this.
Reject policy.
Okay, it is Annexer 12, page number 41.
Yes. This is under challenge.
The order.
It is under challenge in this writ petition.
After the subsequent to the contempt petition.
Subsequent earlier letter that this is under challenge because they themselves have provincialized my court as per government's authority. So how this commissioner can pass this order? He himself on earlier occasion authorized the director to provincialize the post of 125 teachers. Now again the secretary, the government has given the order that he provincialize this post. Now, same government, I think his secretary, not the commissioner secretary. So he's second rank in the department. So how he can reject the prayer for salary by this person when his post was regularized, provincialized by director as per order of the government. That is what you are telling me. You cannot pass this order. And if you have
No.
challenged this,
They can do anything. They consider themselves as the appellate authority of the High Court. They can do anything.
plea they may take this and that, there is no end of the plea taking. This or that, but ultimately justice should prevail well. It is the way, however, a poor teacher is being deprived from his entitled salary, enforceable salary since last 19 years.
Page 43 below, my lord, the reasons are given, my lord. It's the record, my lord. Lordship, allow us. Page 43 below.
Supreme Court in some cases has come heavily on the government advocates who are submitting something beyond that. I may provide the judgment. In the case of.
You should not make personal remarks, my lord. All the time he's making personal remarks.
Personal, not your submissions are in the executive instruction is beyond record. This is the wastage of time of the Honorable High Court. You have paid who is in 123 number, exactly same like 148 you have paid. And so why there is difference? Article 14.
Okay. Heard Mr. Mahmood, learned counsel for the petition, and also heard Mr. Hukun, learned standing counsel for the respondent in elementary education department. Person to order dated 4/11/2025, Mr. Hukun has obtained instruction and produced one letter of the Joint Director Elementary Education, Kailipara, Guwahati, dated 13th of November 2025, addressed to the Secretary to the Government of Assam. Requesting to issue necessary instruction for taking further necessary action for compliance of the order dated 4/11/2025 in WPC number 7058 of 2015. And Mr. Fukun, on the basis of the said letter, press for listing the matter after a week. After a week. Where is allowed? The letter letter dated 13th of November 2025 indicates that as per report of the District Elementary Education Officer Bongaigaon, the petitioner was initially appointed as assistant teacher in different English madrasa, the different Middle English madrasa by the District Elementary Education Officer Bongaigaon during the year 1993, that's 1994, without following any selection process. Accordingly, Mr. Fukun is directed to produce the relevant file based on which the aforementioned observation has been made in the letter dated 13th of November 2025. Further, Mr. Fukun is directed to produce the photocopy of the select list prepared by the subdivisional committee as observed by the secretary to the Government of Assam Education within bracket ILI department in the impugned order dated 28th December 2014. List the matter on Friday.
Director's pronunciation order, that may also be. Record of director's pronunciation order, that may also be produced.
Which order?
Director's pronunciation or course. So that order may be also called for.
No, that is already here. Part of the record, why it is necessary again?
No further, that may kindly be provided. I am hungry, that is why.
Okay, on Monday, next Monday.
24th.
Monday. The letter produced before the court today shall be marked as Annexure X and be tagged with the record.
Running again, 45.
Record is for the lawsuit availability, lawsuit coming from this. Admittedly, there is no show cause before the proceeding was drawn up. And the review lawsuit, I think about the other thing might not have been submitted in order. That is available in the note sheet, might not. Nine six order, 9625.
Yes. So he is not the appointing authority. He is not the appointing authority.
It should not be lower than the appointing authority. Disciplinary authority should not be lower than the appointing authority.
So
And-
he has no authority to
Yes.
suspend him. And on such count, the impugned order will go.
And another show cause notice before the issue, before the proceeding was given to the, although he has not made the
Well,
submission.
Different aspect, man. Different aspect. Particular proceeding. I am on the submission only presently, Michael. Let the.
In this petition, you have only challenged the suspension order.
Suspension order.
Then
That means
your
let us-
ground is he was suspended by a authority who has not been authorized.
That is one aspect. The other is, my lord, more than, my lord, 6 months has passed. They have not reviewed the suspension order.
It was reviewed on 9/6.
That is not
Then
reviewed, my
it
lord,
was,
as in terms of the official
in the note.
memorandum, my lord.
No,
I am
even though,
submitting on a law point. I am not on the effective. But lordship, 3 times he was transferred from one school to the other on the ground. Lordship, he is abusing the students by sending vulgar messages. So lordship, liberty may be given to the BTC authority to take appropriate action as per law. It's as per law, my lord.
Lord.
Because this person should not be allowed to continue, my lord, but lordship, that would be, your lordship's order would be without the authority of law unless the department follows the procedure, your lordship. So in the event of the matter, liberty may be given to the
Already-
BTC to take appropriate steps as per law, my lord.
Already they have
Because
initiated the
this
process.
continues the service lordship, the school, the detrimental for the students, my lord. If sending vulgar is a part of the record, my lord.
no. Even if we not make any such observation in the order,
Yes.
are you not entitled to proceed against
They
it?
can
Then why liberty is necessary?
not recording in liberty from this court, my lord. But on 24/9/2025,
Okay, we'll see.
My lord.
24/9/2025, the submission was made that in disciplinary process has been initiated, inquiry was made, and they were supposed to, my lord.
Not there. Now we have come out. I
Okay,
am submitting on the law point. my
okay,
lord.
okay.
So, my lord, my simple prayer is to let the suspension order go, and I may be reinstated. And, my lord, the date of suspension, my lord, till date, my lord, I have not been paid the subsistence allowance.
There will be direction to pay your salary and the subsistence.
My lord.
Records and submitting can be observed in the audition or the records.
No, we will return the file to you. We will pass the order today.
My lord.
You can take it take back from him.
Gosh, only my prayer that liberty, your lordship can observe in the order.
We'll see. If necessary, definitely we will observe. Otherwise, we will not. We'll see.
Alright.
Okay.
Bill 47.
Malad, these are the matters similar in nature, madam. Here we have filed one affidavit in WBC number 4331/2025, and it will cover all the matter, madam.
Okay.
And as per my instruction is similar instruction I have received for all this, madam, district.
Earlier, my lord, the director rejected our case on the ground that the resolution of the, my lord, district security committee was not forwarded to the, my lord, director. Now, my lord, it is the, my lord, inspector of schools has to file an affidavit, my lord, whether the resolution, my lord, were submitted before the director or no. It is apparent on the, my lord, record, that is page 31, that, my lord, record was earlier sent. But the director, my lord, the State Level Executive Committee rejected our case that, my lord, resolution was not submitted before the, my lord, director.
So what is your pair in these petitions?
Our prayer, my lord, is that, my lord, our name should be, my lord, before the State Level Executive Committee afresh. We need the, my lord, our case afresh.
No, how, Mr. Sharma, without placing the matter before the district scrutiny committee, how it came to be listed before the state level committee?
No, my lord, here, as for the minutes, page 61.
You have filed your affidavit.
Yes, madam. We have filed our
I see, no, no, it was-
in 4/3/2025.
Page 61.
61.
Page 61 is not here.
If you have any,
You have filed your affidavit.
Yes, ma'am.
When?
11, 5, you see.
Mr. Kayum, you have received the copy?
Yes, my lord, I have received the copy.
When did you file, Mr. Sharma?
11, then
11/11. But there is no record.
No, তাতে copy আছে নেকি? একটু দিক না।
নাই না affidavit তো?
No affidavit. কোথাও ধরে একবার affidavit না হয় না। Date for admission, 14/11 of 14/11 of 5 inches, 11 of 9, 14/11 of 5 inches. Sectional record to 9 section of.
Okay.
As per their Eastern Miller, on the date of scrutiny of the state level scrutiny
No,
committee.
that's all right.
Malad,
The state level committee, scrutiny committee has rejected your claim as there is no recommendation from the district level committee.
Recommendation, the resolution was not there.
Okay.
But what is the resolution? But your lordship, for time being, only my lord.
Recommend the name of the petitioners for provincialization of their services due to non-availability of resolution.
Okay.
Resolution of the district scrutiny committee.
No, Mr. Sharma, are you sure that there was a resolution?
Yes, my lord.
There was a resolution.
Yes.
That resolution is part of your affidavit?
No.
No.
Minus is there, minus. Is the minus and minus.
Page number?
In the affidavit.
Here is also minus. Minus serial number 50. Serial number 50, percentage oil. DSC brewery not recommended earlier under the Act 2017. In the latest DSC report, right number CLS dated
26.
8/2019.
26/6/2019.
DSC resolution has not been furnished. Not eligible as per section 2H under Provincialization Act of 2017 due to non-availability of the DSC resolution.
Then
So
now your lordship may kindly turn to page 31, my lord, that letter, my lord,
and
2019.
these are the candidates 50, 51, 53 and 55 minor.
52.
Here in the serial number. 50, 51,
Go to 52,
53
no, 52 also. Alauddin Mullah.
and
Go to
55 also there. Abdul Gopal.
One is Prasenjit Roy, another is Lutfur Rahman Mullah.
Yes.
55 million, all the petitioners in 4 petitions. Item number, my lord, 40,
Up to 55.
yes, my lord. All petitioners.
Here is petitioner named as Abdul Jalil.
Yes, there is there. No.
So, but now the question is whether there was any resolution of the DSA.
Yes, madam.
Yes.
As per this minor, yes, no resolution. For these candidates, madam.
And what is your instruction?
Lordship may kindly see, my lord. That, my lord, man from India, my lord,
Page
minus
number
of-
31.
DSC resolution has not furnished. Only there, my lord, it is not furnished.
2019.
Not been furnished.
To the that, my lord, subject submission of particulars of drop employees in different schools, so and so. That reference the office letter number so and so 16 May 2017. Sir, with reference to the subject letter above and in continuation to this office letter under reference above, I have the honor to submit here with the particulars of drop employees of different school provincialized during the year 2013. Duly recommended and approved by the district secretary in its meeting held on 6 September 2017 with its minutes as stated as asked. And now your lordship may kindly turn to page, my lord, 29. The minutes of the, my lord, district secretary committee,
Page number?
page 29, my lord. The type copy, my lord, and the vernacular at page 30 minutes. Page 29, my lord.
Page 29.
29.
Hmm.
Lordship got me.
Yes.
The review meeting of the district student committee, then my lord dated September 2017. It is, yeah, I have an explanation. They say that my lord, the district student committee has not my lord, submit that manuscript. And there my lord, the resolution is there. At the very beginning, the inspector of schools, DDC, become member secretary, district committee, Dhubri, welcomes the house and express the aim and objective of review, district student committee meeting, and requested the house to re-scrutiny on the matter which have detected mistake in respective cases of drop teacher of same school at last district scrutiny committee meeting held on 16 May 2017. There was another meeting, my lord, earlier, that is 16 May 2017. After threadbare discussion, the house decided to re-scrutiny the particulars of the drop teachers of different schools and accordingly made rectification through scrutiny and finalized in the light of Assam Education Professional Service Rules 2017. Finally, the house requested the inspector of school Dhubri for sending the approval list to DSC Assam. That is there. Now they say that the
So,
resolution was-
no. You could not obtain a copy of the resolution.
Yes, yes.
Mr. Sharma,
Yes.
are you sure that there was a resolution?
Well, here it is stated that in against the my lord 51 in any matter. Here that
Whether that
Not
district
eligible.
the district committee is a party here?
Yes, my lord, the inspector of schools,
due to non-availability of DSC resolution.
the inspector of schools, come member secretary of the district school committee.
District scrutiny committee. So, Mr. Sharma, you are representing him also.
Yes, ma'am.
You obtain a copy?
Yes, but the IS my lord make my lord affidavit that whether that resolution was submitted or not. If submitted, my lord, normally it is submitted. But so for my lord, director sponsor, my lord, they say that not submitted.
Whether you have mentioned the same in your affidavit?
Yes, madam.
Have you enclosed that copy of the resolution?
I have enclosed this as annexure 1, madam.
Annexure 1.
Yes, madam.
Whether the name of the petitioners are there?
Yes, madam.
Then
50, 51, 53 and 55.
52, 55.
their names are there.
Next.
Then what is your stand then? No. Rejected on account of absence of the resolution. Now we set aside that observation of the state level committee. You place the matter before the state level committee again.
If there is no resolution from the district level scrutiny committee, in that circumstances, again, result will be appeared.
No, that resolution is part of your affidavit.
This is the minutes.
Yes, not of district level.
No, my lord.
Then you file a short affidavit enclosing the resolution of the district level committee of in respect of this respondent number 4 by next week.
Sometime maybe.
I'm no problem, my lord, because my lord, they are writing since 2013. Severely employees have been provided. My lord,
Heard Mr. Kayum, learned counsel for the petitioner, and Mr. Sharma, learned standing counsel for the respondent in secondary education department. Mr. Sharma has produced. No, Mr. Sharma submits that one affidavit has already been filed on 14/11. 11/11, but the same has not been placed on record.
my lord, in WPC 4331 only 2020.
In WPC number 433 of 2025, but the same is not been placed on record. And accordingly, it is provided that registrar shall list the matter after a week by taking the affidavit in opposition filed by Mr. Sharma, learned counsel for the respondent authorities. Further, it is provided that Mr. Sharma shall file an additional affidavit for respondent number 4, enclosing the district level scrutiny committee resolution minutes of the meeting of the district level scrutiny committee, by which the name of the present petitioners are recommended. For being appointed as assistant teacher. Assistant teacher. List the matter on. Okay, first week of December. The letter produced before the court today shall be marked as Annex A and be taken to the record. Over.